Well, good morning.
Good morning. Good morning.
I'm just going to talk about the Joyce livestock case and then answer questions. In answering questions, I can't give you legal advice about anything you may have, problems, or answer how the court would rule in hypothetical cases that may come in the future. So I'm just basically want to give a good explanation of the Joyce case and Joyce livestock case, and hopefully understand the issues there, what the government argued, and how it was resolved. And as I won't go into who Joyce Livestock, what Joyce Livestock is. You know, obviously it was a ranching entity that went back in probably over 100 years by the time this case came up. I think they had 10,000 acres of deeded land that accumulated from various homesteads over the years. And so the issue, when they wanted to file for water rights on federal land for what we call in-stream water rights to water livestock, and the federal government objected on various grounds. And now in-stream water rights don't have to be in a stream. It can be a spring, it can be a river. We call it in-stream water rights, but Idaho had years before recognized that you could get a water right for stock watering without diverting the water. Generally, water rights, you would have to divert it from a water source and apply it to a beneficial use, but in in-stream use, you didn't have to divert it. But it's only, so that would have been recognized years earlier by our Supreme Court. And so the issues that were raised, number one, was whether you can get a water right on federal land, for water sources on federal land. And we had a 1921 case which says one who's appropriated water and beneficially used it has the right to use the water independent of the ownership of the land. And obviously, if you had to own the land where the water source was located, it'd be pretty hard for a lot of people to get water rights, because how many of you own the Snake River? That was obviously kind of a non-starter argument, but that was one of the arguments made. The United States Supreme Court also, or not, the United States also argued that until the Taylor Grazing Act, ranchers did not have the right to exclude people from water sources where they were grazing their cattle. And so you couldn't get a water right until that act was passed. But again, having a water right doesn't give you the right to exclude anyone else from that water source. If you have a water right out of the Snake River, that doesn't mean you can exclude other people from using water out of the Snake River. That again, we've never held that, and that was an argument raised by the United States, but obviously it's a non-meritorious argument in that respect, because there's never been a requirement that you be able to exclude other people from using a water source from which you're getting water. Now, obviously, if the water source is on your land, you may be able to exclude people depending on the facts. But if it's on somebody else's land, if it's a river or a stream that you divert water from, you don't have the right to exclude other people from diverting water from that same water source. And so, again, that argument was rejected. The United States also argued that and the district court agreed, that you could not appropriate water unless you could prove that the person who initially appropriated had the intent to obtain a water right. Well, again, appropriation is just, normally diverting the water and applying it to a beneficial use, or within stream, just using the water for stock watering. You don't have to prove that the person, when they were doing that, knew that they were going to be able to acquire a water right. We don't require people using water and applying it to a beneficial use to be attorneys, or to be knowledgeable of water law, or to know exactly what steps are necessary in order to divert water and to get a water right. Basically, it's just either divert it and apply it to beneficial use under the constitutional method, or within stream, just water your stock in it. And then ultimately you'll get a water right. You know, we don't, and so again, that argument was pretty easy to reject. And then our federal government also argued that you would have to have direct evidence that the person who initially got the water right back in the 1800s knew of all the water sources on the federal land where that person's cattle were watering, usually cattle, could have been sheep, or you know, was personally aware of each of those water sources. Well, that, you know, common sense is if I'm going to be a rancher in Hawaii County, for example, I'm not going to buy a whole bunch of cattle and then wonder if there's any water out there that I could water them with. You know, obviously the people that were obtaining, you know, had their cattle grazing on federal land would only do so if there was water there for the cattle to drink. And so again, that's not an issue. You know, you don't have to know that the cattle are drinking from this particular source or have you don't have to have direct evidence that this person went out and mapped all of the springs and creeks and whatever where the cattle were grazing and made sure that that person actually knew them. It's just, if the cattle are there, they're going to go where there's water, and they're going to drink from any spring or a creek or whatever that they can find. And so that was, again, that argument was rejected. The United States also claimed it had water rights on the land, that all the people who were grazing on federal land were basically the agents of the federal government, and so therefore the water rights were the federal government's water rights, not the ranchers or the stockmen's water rights. But again, that's not the law. And there was no evidence that these people were seeking to obtain a water right as an agent of the federal government. In fact, most of them, you know, in this case, started, you know, the grazing started long before the federal government even started to control grazing on federal land. People that came out here in the 1800s and started grazing stock on the federal land. You know, they'd usually homestead with their 160 or whatever they could at that time when they came out, and they would homestead an area typically where there was water, where they could raise some hay or something, and then they would graze their cattle during the spring and summer and into the fall as long as they could on federal land rather than on their own land, and then bring it back and maybe winter it on their own land or grow hay or something. So you know, that's the way it was done, but obviously they were not trying to get water rights on behalf of the federal government, and so they were not the government's agents in doing that, and so that argument was rejected just because there's no agency. You know, you can obviously have a tenant on your property and authorize the tenant to go obtain a water right on your behalf to use, and if they're your agent, then that can be your water right. But the facts didn't fit that scenario. These people were not. People didn't come west to be agents of the federal government, and so so that was easily rejected. There were the two. Obviously, one of the key issues but it was really not an issue on the appeal, is that trying to prove, when you have a ranch that where your predecessors in interest started ranching, 100 years ago, being able to prove when they started bringing cattle onto the federal land and how many cattle there were, obviously can be maybe an issue. But that wasn't an issue on appeal in this case because the trial court had ruled that they couldn't get a water right until the Taylor Act was enacted. And so obviously we said you can get a water right before then, so it had to go back for a determination of when the water rights actually began, based on their predecessors, and then how many cattle were being raised, and obviously that could increase over time, particularly in a situation like Joyce Livestock, where it acquired multiple homesteads, and they were not necessarily all homesteaded at the same time. But that was not an issue on the appeal. The two biggest really issues on the appeal that we did not have prior case law on, or that could not be rejected out of hand, were first of all, the federal government argued that the water rights obtained on federal land could not be pertinent to the deeded land because the water was not being used on the deeded land. And so that was their argument. We didn't have any case law on that because generally the water rights in our prior case law had dealt with water that was diverted from a source, conveyed to the deeded land, and used on the deeded land. However, I did find a case that had to do with an easement. And in that case, the deeded land, the person took their cattle down a road, and this court held that they had an easement on that land they crossed, that private land they crossed, that was appurtenant to their land, because they later then sold the deeded land, and subsequently a subsequent purchaser then was barred from using that easement, and so they sued, and we held, yeah, that's an easement appurtenant to that deeded land and what was the land. Well, we had also cases that analogized water rights and easements as to how the law applicable to them. So it was pretty, that I just said basically that reasoning by analogy, if the easement is appurtenant to the land, then the water right can be too, even though the water is not used on the deeded land. And so that was probably the main issue in the case, that because there was no other case law directly on point. Then the issue was, well, if the deeded land had been conveyed multiple times, and a lot of the deeds didn't mention water rights. And so the United States argued that, well, the water rights were not conveyed then with those deeds. But our law is that water rights are appurtenant when they're appurtenant to the land, and you convey the land, the water rights go with it unless you expressly reserve it. And so the fact that the deeds did not mention water rights didn't mean that the water rights didn't go with the deeded land. There was water rights that were appurtenant to it, because none of the deeds reserved the water rights in the seller. And so all the water rights then went with the deeded land each time it was sold, even though the deeds did not expressly mention the water rights. And so those were basically the main issues in the case. That you can get a water right on federal land for in-stream stock watering, that is appurtenant to your deeded land, and it would be conveyed with your deeded land, and you don't have to prove that the person had mapped all of the springs and whatever on the federal land before they went out and started watering their stock on it. You could logically assume that if somebody's going to put their stock out on federal land to graze, that they would have looked to see if there's any water there for the stock to drink. That's not a big leap. That's pretty common sense. And so that's basically what that case was about. But to me, the biggest issue was our holding that the water rights on federal land are appurtenant to the deeded land of the person who's watering the stock. And so that will, because that's the way, and that would be what everybody would expect. Obviously, if you have a home place, you would expect that the water rights you acquire on federal land to graze your stock would go with the home place. That's just kind of common sense. But we did not yet have any authority on that, and that was one of the main things, to me, one of the most important parts of the opinion. So